He's running this course, online course, £250 for this rights of mental health, patients with mental health. This is not a member of IPS.
He's not a member.
But how he was nominated by any IPS is nothing to do with IPS. The government has selected just like that.
Yeah.
Probably the government wants somebody who is not a member of IPS.
No. But just a coincidence that Jaya Sagade is vice principal of Pune Law College. And so they were running a course. That's why because of his connection with WHO, he's running some courses.
So the fact that he is not a member of IPS, maybe he is negative to IPS as a psychiatric profession.
I tried 100 times to make him negative.
So that itself shows that probably is not comfortable with the other professional colleagues, the society. Something like that. If such a reputed man is there, he should have been our member.
Vikram Patel would have
Right, sure.
introduction.
Yeah, we are there, and Alok is going to talk to you next.
How do you put the speakers on?
Hello, sorry. Yeah, I can hear you. Okay. Is there some way of increasing the volume of this? No, I'm asking Dr. Kala actually. I don't know. Okay.
You hold it a little lower so that the speaker gets on.
Yeah. Okay, Somit, I have your presentation.
Yeah, voice is connected.
Can just hold for a moment and we are going to try and connect this. Yeah. Okay. Say something. Hello. Hello. Somit?
1 second, he's increasing the volume from
Okay.
I was going to do it. There are 42 slides. Maybe it's not possible to start around.
Yeah, we'll go through.
Okay, maybe the highlights. Because I'm sure there are
No, not one by one.
Yeah.
Somit? Hello? Hello? Huh? No, it's already, it's at full.
Somewhere the connection is wrong.
No, it is. In the website it's being held.
Hello.
Yeah. Hello?
Hello, can you hear me now?
Yes, sir.
Now, loud and clear. Okay.
Okay, good.
Okay, I have your
We can
slide.
start.
Yeah, we are ready to start. I have your slides here in front of me, and we have a large audience, all waiting agog to hear you. Okay.
Hello, you have to interrupt me in case you can't hear me or if something goes wrong.
Okay.
Can I start? I'm really sorry that I have not been able to come there because of my health problem, and just would like to apologize to all the organizers, including Dr. Kalyan Sundaram and Roy, for creating this little bit of a nuisance for everyone. But while I'm on the phone, let me just try and get through all the questions that had been raised. Alok, if you can move it to the second slide, which says communication from IPS regarding the MHC bill. You have that now?
Yeah, we have that now.
Okay. So in this talk, I was going to rely on these following communications that we received from the Indian Psychiatric Society. Two of them are letters from 2010. There is a letter from 2011, and then there is a position statement from April 2012, which was forwarded to me by Dr. Kala. I haven't actually seen the printed copy of it, and I do not know if that was sent to the ministry or not. Can I have? There is one more presentation, there is one more communication I will be talking about, but that's later in the talk towards the end. If I can move to the next slide, please.
Yep. Okay.
In the April position statement, as I see it, there are 18 points which are mentioned, of which the first 3 points are really congratulatory in terms of the bill being good and everything. And the remaining 15 are specific concerns which were mentioned. So I'm going to try and get through those 15 concerns which have been mentioned. Okay, if I can have the next slide, point number 1, emergency treatment.
Okay.
We have made, this was a comment which came not only from the IPS but also from professionals living in the northeast and in the hill states. So we have increased the provision for emergency treatment there to 120 hours. And there is also another one clause in the bill which says that in disasters and emergencies anywhere in the country, emergency treatment can be increased up to 7 days. If I can have the next slide, please.
Sure.
Point number 2, which the IPS had made, was they wanted to see that the duration of the supported admission should be at least 40 days. If I've actually copied out what the IPS had said. If I can move to the next slide, I'll tell you what the status is.
Done.
We haven't changed that to 40 days. It has remained as 30 days. And the reason for it is as follows, that not all patients will continue to remain in a state where they do not have capacity to make decisions for 40 days. We know that the average length of stay in most acute inpatient units is about 14 to 20 days. And even if this section says 30 days, the admission can continue beyond 30 days. After 30 days, if you feel the patient has now got the capacity to make decisions, you can continue them as a voluntary patient, or you can extend their admission under section 99 for another 90 days. So in a sense, it's not like anyone's going to get completely inconvenienced by it. And given the international norms for such admissions also tend to be 4 weeks or 30 days, we left this at 30 days. As it is, we have faced a lot of criticism from people saying that 30 days is too long and this should actually be only 10 days or 15 days. So, it's a matter of whether it should be 30 days or 40 days, and for now we've left it at 30 days. If I can have the next slide.
Yep. Okay.
Point number 3, which is the IPS's point, was that this should be 180 days. And that is partially true, because the way the section is framed just now, the first renewal is 90 days in the first instance, the subsequent renewal is 180 days. And a third renewal will be 180 days, 120 days, and then 180 days at each instance. So basically, when you come to the third renewal, then you would get 180 days. So in cases of long stay patients, you would be able to renew it 6 months at a time after the third renewal, from the third renewal onwards. So I would say that we've kind of partially done what the IPS wanted on this particular clause. If I can get the next slide, Alok.
Yeah. Soumitra, there's a question here from the chairperson.
Okay, I can't hear you, Alok. If you maybe pull up the phone to your ear, to close to yourself, and then I could try and answer it.
Okay.
Yeah.
Can you hear me clearer now?
Yeah, I can hear you clearly now.
Okay. The chairperson, Dr. Chavan, says that there are 42 slides.
Yes.
We may not have that much time.
Yes.
So, can we skip to the sort of the relevant, or I'm sure all of them are equally relevant. But,
Okay.
Yeah, but can we sort of wind it up in 5 minutes?
Let's see August, guys.
I'm
Because we don't have anything else. We don't have anything else to do.
We are having a single slide. Okay.
We have time till 6:30.
Absolutely. Let's go through all of them. Okay.
Okay, so then, well, I'm already on slide 8, so it's not going to be a lot. I mean, point 4, if I can get to point 4, the slide which says point 4.
Yes, you're on 4.
Yeah. See, the thing is that I wanted to clarify to people that in terms of the involuntary admission that IPS is talking of, the requirement is not to send a report of the admission. The requirement is only to inform the district court that there has been an admission. So that's not a requirement for a detailed report to be sent. And the reason for having this is that there have been concerns about abuse of these kinds of provisions. I'm sure all our colleagues there know that Section 19 and Section 20 have repeatedly, more than Section 20, Section 19 have been repeatedly in the news because of allegations of abuse. So in a sense, we put this up as a protection in a sense that, okay, we inform the district board that somebody's been admitted under this section. If I can have the next slide, please.
Yep.
Point number 5 was this concern that for section 99, see the IPS letter refers to section 46, but that is the previous draft. In the current draft, which is on the ministry's website, that section 46 is section 99. So I have written the section 99 in the bracket just in case people are getting confused why we have 46 and 99. But section 99 is largely to do with admissions which continue for 90 days or 120 days or 180 days at renewals. And it's concerned that the district board has to approve each of these admissions, and the IPS feels that will create a problem. See, the answer to that is, if I can get you to move to the next slide, is that the patient may not be in a state to challenge the admission. As you have probably noticed through the bill, we have removed any judicial intervention at the time of admission. So, when people are being admitted to hospital, they are being admitted without having to go to the magistracy to get any kind of magisterial orders. And that was done largely so that people's treatment is not delayed. But in the case of this particular section, we feel that the person is already in the hospital. And after 30 days, if you're going to renew it for 90 days, then that kind of is a right time when a judicial review, independent judicial review or a quasi-judicial review should happen. And it's also a requirement for us to ensure that we meet the requirements of the Convention on the Rights of Persons with Disabilities, the CRPD Convention, which talks about an independent quasi-judicial review which needs to happen when people are, whenever there's any restriction on people's legal capacity. What we have done there is we've taken into account of the clinical needs, and Dr. Kala is there, and sir will remember we had this discussion that we do not want to inconvenience patients, families or professionals. So what we've said is that the board should actually hold the hearing at the establishment itself where the person is admitted. So we made that provision that the board may conduct the proceedings at the facility itself, and that you do not have to take the patient, the doctor and the relatives up to some other place. I hope that kind of meets the requirements of what we need to do, at the same time ensure that the inconvenience that is being caused to people is kept to the minimum. If I can get the next slide, please.
Yep.
There's point number 6 was that there should be some provision for short admissions of 7 to 10 days. My understanding is that the current provisions of the bill actually allow short admissions. If you use the section 98 admission, which is up to 30 days, then it is a short admission. You can discharge people after 7 to 10 days. There's nothing to stop you. In addition, there is also an emergency provision which allows treatment for 72 hours at the home or hospital. And that emergency provision is without any requirements of any certification. So, in fact, the emergency provision allows any general practitioner to provide treatment. It doesn't even have to be a psychiatrist. So, if you've got a person who's seriously ill at home and needs treatment, then you can actually treat them at home. And we even said that emergency treatment includes transferring people from their home to the hospital. So you could use the emergency provisions in a real emergency to move people from their homes to the hospital setting. So my understanding is that there is nothing to stop people from being admitted for 7 to 10 days using section 98. If I can have the next slide, please.
Soumitra?
Yeah.
This is Anirudh Kala.
Yes, sir.
Okay. Now, see, the impression that people get here is that the paperwork, when you increase the paperwork too much, you may not say it, but you are actually discouraging longer admissions indirectly. Now, and the second thing is that as far as the DMHP inpatient units are concerned, that we recently have done these reviews for the previous plan, and almost all the DMHP units were grossly understaffed, in the sense that you do not have a psychiatrist plus a mental health professional in most of the DMHP inpatient. So how are involuntary admissions going to happen there?
Sir, in case of in case of the section 98 admission, which is admission for 30 days, you need one psychiatrist and you need another medical practitioner. So you don't need two psychiatrists.
You in that unit you do not have. You may not even have a psychiatrist. You may have a general duty doctor who has gone 6 weeks training. Many of the DL.
Sir, the question is that, in fact, one of the things that IPS has repeatedly been saying to us that under no circumstances anybody other than a psychiatrist should certify admission.
Yes. Yes.
Is there,
So-
now having, gone through this, do you think there is any way to facilitate involuntary, very short involuntary admissions at the district level in the USP program?
So you mean for the 7 to 10 days, is it?
Yes.
And who should be doing them? I didn't understand. Are you saying they should be done by even people who are not psychiatrists?
Yes.
So wouldn't you be able to use the emergency provision that gives you 3 days anyway?
3 days is too short.
So 3 days is too short, but is it something that without a psychiatrist you would want to continue admissions beyond 3 days?
Okay, we'll leave it at that for the time being and go on to the next
Okay,
slide.
sir. Okay.
Now, this is the real contentious
Yes.
thing. Chitranjan, we just heard Chitranjan and Rade
Yes.
argue about these provisions being there at all. And in fact, Chitranjan, can you come here and talk on... now, on to Chitranjan and Rade.
Yes, sir.
All right.
Saumitra, can you hear me? I'm Chitranjan Andrade.
Yes.
We are
Yes, I can hear you, sir. I can
we
hear
are on
you.
point number 7. Would you take over from here? I had my notes afterwards.
Okay, sir. So point number 7, I think people must have read it, that basically IPS feels that there should be no blanket prohibition of ECTs for patients below 18 years. And the IPS has also said that checks and balances would be welcome to ensure that the treatment is not abused. And I think we've done that. If I can move to the next slide. We have done that. There is no blanket provision of ECTs for minors. What the provision now reads is what you have there. That if in the opinion of the psychiatrist in charge of the minors treatment, ECT is required as a life-saving procedure, then such treatment shall be done with the consent of the guardian and prior permission of the concerned board, which is very similar to what everyone is saying about having checks and balances to prevent any kind of abuse.
Now, I have a comment over here, Saumitra, if I may interrupt you
Yes,
in the
sir.
interest of time. The provision which has been modified is still a problem for us because, firstly, ECT is permissible now for minors only as a life-saving procedure. But what if it's not a life-saving procedure? For example, the patient has treatment-refractory illness, treatment-refractory mania, schizophrenia, rapid cycling bipolar disorder, treatment-refractory depression. If the patient has a symptom which is treatment refractory, like head banging, for example, like tics, for example. There are data to show that ECT is safe and effective in all these circumstances. So restricting it only to a life-saving last resort seems to be denying pediatric patients of potential treatment.
Okay, I understand your point. Yeah.
I'll add something over here. With regard to checks and balance, there's already a position statement and guideline on ECT for minors issued by the American Academy of Child and Adolescent Psychiatrists in 2004 and published in full, which I can send the whoever it is who's drafting the MHA. So, given that these documents already exist, documents prepared by a scientific body, documents prescribing all indications, contraindications, and the checks and balances, why would the government need to get into this act at all? Why would the government want to tell us how to treat or not to treat a patient?
So the fact of the, let me try and answer your first question, which is that I understand the difficulty with the phrase life-saving procedures, and maybe we need to reword that or look at how that can be reworded so that it does not create the problem that you say, which is that if somebody's got a a condition which is not going to respond, and it may not necessarily be a life-saving issue, although I would argue that it is life-saving, but yes, that needs to be clarified and we need to look into that. But the second issue is that in terms of why should the government get into this, I think the fact of the matter is that almost all of medical practice in this country and across the world is regulated.
No, not by the government, not as law.
You know, there are it is regulated. Like for example, in our country, there are regulations around the use of ultrasound for sex determination. There are regulations for organ donation. There are regulations for many other conditions. So this is not something that is specifically for psychiatry per se. We often, given the social issues around certain treatments, that
Hello?
provision is needed. Hello?
Yeah, please go ahead.
Yeah, did you hear what I said the last bit?
Yes, we heard the last bit, but we are still not convinced that life-saving needs to be there at all.
No, what I said earlier was that phraseology of is required as a life-saving procedure needs to be reviewed, I think. And I think that's something that we need to take up with the ministry.
May I make a suggestion? We can change it to treatment for refractory symptoms or illness.
Okay. Sir, can I suggest that you just write a mail or something, drop me a mail because I'll say yes, I may not remember it later or it will get forgotten. If you just drop me a mail, then it stays on my computer and goes into the list of things that we need to take up with the ministry when we talk to them again about it.
Okay, I'll do that, but personally I'll also add that we think that the whole section on ECT needs to be removed, and I'll send you the justification for that also. So perhaps you can proceed with your presentation. We go to the next slide, point take on unmodified ECT.
Yes. On the whole issue of unmodified ECT, I mean, I've just, if people want to read, this is the IPS's position on it. And if I can go to the next slide, I'll try and answer each of these issues, okay? The World Psychiatric Association, and IPS is a member association of the World Psychiatric Association, that also opposes unmodified ECTs. And what I've copied out there is an extract from the WPA statement. It says that national member societies of the WPA, in collaboration with their governments, are asked to implement WPA declaration statements and guidelines on ethics. And consider the recommendations of the WHO resource book on mental health, human rights and legislation with the following aims. And if I can just continue on the next slide. If I can get you to read point number 2, it says to implement modified ECT as standard practice for every person who needs this treatment. And point number 3, to cease the use of unmodified ECTs in view of evidence indicating that this method has no difference in effectiveness from modified ECTs, but has more adverse effects. This is the WPA's position on unmodified ECTs.
Okay, I'd like to add something else over here. Sorry to interrupt, but I'd like to add something over here. The WPA position statement on unmodified ECT was largely based on a paper which I wrote in Journal of Clinical Psychiatry in 2003. Additionally, the IPS now has a new position on unmodified ECT.
I've seen the IPS's new position, sir. I'm trying to give you a different point of view. That's all. I don't disagree with that. I read the IPS position. I'm just trying to, let me go through the next 2-3 slides and then I'm very happy to discuss this further. Would that be okay?
Yeah, please go ahead.
Yeah. On the next slide, it says, again, this is from the IPS position, WPA's position, which says to urgently make every effort for the creation of necessary infrastructure for the provision of modified ECTs. And this is an ethical obligation on part of governments, professional organizations and individual practitioners. So my reading of it is that the IPS should be lobbying government for district hospitals to have an anesthesia. And that individual practitioners also have a responsibility to create the necessary infrastructure for unmodified ECTs. So, you know, if you read the WPS position in the way it is read, then the onus of the IPS is to try and lobby the government. If I can get you to the next slide, please, which says the WHO position. And the WPA also endorses the WHO's position. You know, the WHO resource book recommends banning of direct ECTs, and the resource book was prepared after lengthy consultations with a large number of stakeholders. So it's not something that just happened by 1 or 2 people writing it up. If you look up the resource book, it has nearly 200 people who reviewed that resource book before the WHO adopted it as its position on the treatment of mental illness. And by the way, if I can point out, the WHO resource book actually also recommends banning ECTs minors. But leaving that aside, in terms of direct ECT, it's very clear the WHO is saying the same thing. And the European Committee on Torture is very clear that in instances where ECT is done in the unmodified form, it could be regarded as what is called as inhuman and degrading treatment. So, there are a lot of international agencies from the professional side, as in the WPA, from the health side, which is the WHO, and there are the human rights organizations such as the CPT. All of whom are saying that unmodified ECTs is not acceptable.
Soumitra, you need to say something over
so
here.
let me, this is the last
Okay,
slide, sir.
tell me when I
Let me
can come
come
in.
in. Yeah.
Tell me when I can come in. Finish what you have to say.
Yeah. So the other issue is what IPS said about not having anesthetic support. If you look at, there are 16,000 anesthetists in this country, and there are only 4,000 psychiatrists. So, I cannot believe that we are going to have a situation where a psychiatrist is available, but an anesthetist is not available.
The ground reality is that
I
it is not
really do not understand that happening. And the last and final point really is that this provision about direct ECTs and about ECTs for minors has been there from the very first draft in February 2010. None of the IPS communications in 2010 or 11 have ever mentioned or raised this issue. The first time this has been raised is in April 2012 now. So, for 2 years we've gone along, there have been repeatedly people have kind of communicated, never has this been raised. So, this is really what I'll stop here and take questions, and I'm sure Director has something to comment on, so I'm happy to take that now.
Soumitra, the ground reality is that there are 16,000 anesthetists, but they are not available for conducting deliveries. They are not available for conducting surgeries, and our district headquarters are short of anesthetists all over the country. This is a ground reality. Don't compare 16,000 anesthetists to 4,000 psychiatrists. Anesthetists are required for large number of interventions in surgical procedures. So the availability in the country, need to give vis-a-vis availability of anesthetist. I don't agree with your statement. I am from the audience.
Soumitra, that was Dr. Shiv Gautam. He was the past president of the Indian Psychiatric Society. I would like to add a bit also. According to the new provisions of the Act, unmodified ECT is absolutely prohibited. Now, there are definitely emergency situations where, as we have pointed out in the position statement in the Indian Journal of Psychiatry, emergency situations in which ECT becomes life-saving to a patient. Now, under these circumstances, if unmodified ECT is absolutely prohibited despite evidence of its relative safety, then I think it's unfair to the patient and to the family and also to the psychiatric profession. Also to say that unmodified ECT, can I finish, Soumitra?
Yeah.
Also to say that unmodified ECT is like torture is unfair. Is cesarean section torture? It's a lot more bloody. Is cardioversion torture? The patient's body jumps 2 feet in the air. Is open heart surgery, is neurosurgery where the hole is made in the skull or where the portion of the skull is removed, and the surgeon puts his fingers into the brain? Isn't that torture? So why is unmodified ECT torture? It's a form of treatment.
This is not my position that it is torture.
But you're quoting it, and mental health
I'm quoting it because these are official agencies. These are not individuals. These are not activist agencies. These are official agencies which are arms of the international human rights system.
See, Soumitra, we are not saying that we want to give ECT to children or we want to give unmodified ECT. We definitely do not want to give unmodified ECT to patients, and we definitely do not want to give ECT to children and adolescents unless the circumstances are exceptional enough to necessitate these. And we already have scientific guidelines, scientifically framed guidelines. We have scientific bodies, we have associations which have determined when it is justified or not, with examples provided, with checks and balances provided. Why should the government get into this at all? Dr. Shiv, again.
Soumitra, there is another point that professional societies prepare practice guidelines for psychiatrists in India, and they are available on ECT, which are given by Indian Psychiatric Society. Now, for a country quoting guidelines which comes from the West, can we accept as such without looking at the ground realities of the country? Are we
This is
preparing?
not about, sir, the issue about direct ECTs is not about guidelines.
Sir, the law interferes with the practice of psychiatry in this country. And if a law is interfering with the practice of psychiatry in a country, can it become the law of the land? We are here to prepare a law for a land. We are not importing laws. You see, that part has to be understood. That import of any law from a foreign country and accepting as such because some practice guidelines from different country has given this. This is a serious issue which has to be, otherwise, you know, like the other laws have not stood the test of time, this also will not stand the test of time. It will remain in the books, but the practice on the ground realities will be different.
Sir, first of all, let me say that the issue is not about interfering with the practice of psychiatry. The law is all about, the law largely is placing the person with mental illness and ensuring that they get the adequate and appropriate treatment when they require. So this is, the law is not about either interfering. Can you hear me?
Yes, yes.
Sumit, I'm just going to come in. This is Alok.
Okay. Yeah.
I think I would like to say one or two things.
Okay.
And the one or two things are this, and this is as much for the audience as it is for you, in fact more for the audience than it is for you, is that that actually Soumitra has been asked by the Ministry of Health to draft a mental health act. And in while I may agree with many provisions and while I may not agree with many provisions, while I do think that many things need to be thought of, Soumitra is not ultimately responsible for the Mental Health Care Act. I think we do need to recognize that a lot of thought and a lot of work has actually gone into this. There will be concerns. We need to, I think that in many ways we should have actually been much more participative, which we have not. Even now, we still need to put down all our concerns. This is not an interrogation of Soumitra, nor should it become. While it's an interrogation of the process, which is fine, we do need to put all this down and communicate this both to Soumitra and the Ministry of Health to see where it goes. I think that's fine. With that, Soumitra, we'll just come to that. If there are any more slides, are there?
Can you be in line? Like we might.
There is some more on the advanced directives. Do you want me to go on that or?
Please.
Yes, yes. Please go on. Please go on.
You want me to continue with that?
Yes, yes.
Yes.
How are we doing for time?
Oh, time, after that, is no session. It can continue.
It can continue.
No problem.
Let's ask him rather than sort of.
Yeah, until 6:30.
Okay.
What do you want to know
No,
from him?
let's only look at the position
Yes,
statement.
yes.
Okay, may
Not the
I
IPS
suggest that we let Soumitra finish in the next few minutes without
Yes, yes.
interruption, and
Yes,
then
yes.
if there are questions, we will ask him.
Yes,
Does
yes.
that sound all right, Soumitra, to you?
Yeah, that's okay with me. Look, if you can get it to the slide which is point 10 advanced directives.
Yeah,
Yes.
we are on 10.
Yeah, so I won't read this out because people would have read it. So
Yes.
I'll just move ahead to the next slide and clarify that advanced directives are optional. So, every patient does not have to write an advanced directive. We do not feel that it places the patient or the families in an adversarial position. And we believe that it gives some degree of choice. It's a way of trying to convert this idea of supported decision making into reality. So, firstly, not every patient has to write an advanced directive. If they want to write an advanced directive, then they can do that. And if you look at advanced directives from across the world, then that is what you got, which is from USA, Canada, and Europe. But what we have is, most advanced directives usually have informed consent for future treatment. Alok, if I can get you on the slide which says contents of AD.
Yeah.
You on that slide?
Yep.
Yeah. So largely it is about saying, okay, what consent for some future treatment or opting out of specific treatments, and also about appointing somebody to act as a decision maker for future treatment. So, you can say, I would like so-and-so to take decisions on my behalf when I'm not in a state to make decisions. If I can get you on the next slide, even in the USA, only about 4 to 13% of patients write an AD. So it's actually a small number of people who write an AD. Almost 60 to 70% of people say they want help to write an AD, but a very small proportion write an AD. And what I've got there is a study from SCARF, which Dr. Thara and her colleagues did in Chennai in 2012. And what they did was they conducted a study where they helped people write an AD. And 92 out of the 93 patients were able to complete an advanced directives. 45% of the patients were symptomatic, that is, they had psychotic symptoms. All patients who wrote an AD wanted to continue treatment. So one of the fears that patients will write advanced directives to stop treatment was not borne out in that. And 75% of their patients were urban and the remaining were rural and mixed backgrounds. If I can have the next slide, please. And this is Chennai study conclusions. I'm not going to read it. I think we should leave it on for a couple of minutes for people to read it. I think the conclusions drawn by Dr. Tara and her colleagues speaks for itself, and I do not need to read them out.
Next.
I see that you don't quote the other work on advanced directives.
Next.
In the press.
Next.
But then we go on.
Okay. Well, this is a biased presentation, Alok. I'm going to quote what I want to support myself, if you see what I mean. I'm sure you've done a talk on advanced directives which has reviewed advanced directives in its totality. So can I move to the next slide if people have read this slide?
Yeah, you're on the next slide.
Okay. So what we've got lots of protections built into it. Firstly, advanced directive is limited to mental health care. So, you can't write an advanced directive about property or finances. We said that 2 witnesses have to sign an advanced directive. We want them to register it with the district board or at least get it certified by the general practitioner that the person has capacity and that the advanced directive was not under pressure and was done of free will. You can't write an advanced directive saying I refuse all treatment. The law does not allow that kind of advanced directive. The advanced directive also doesn't apply to emergency treatment. So, in an emergency, you don't need to be hunting and looking for where is an advanced directive and what does it say. If I can have the next slide, please. Yeah. There is a right to challenge an advanced directive of the district board, and that is available to the professionals, it's available to the caregivers, and it's available to other interested parties. And no advanced directive can be against existing laws. So, for example, you can't have an advanced directive which says, if I become psychotic, please do euthanasia on me or something like that, because that would be against existing laws. And most importantly, we indemnify medical professionals in both ways. One is that if the advanced directive was not given to you, you can't be expected to follow it. And secondly, if you followed an advanced directive, because it was a valid advanced directive, if there was any negative consequences of that, then you are indemnified from that. You cannot be held liable for negative consequences arising out of following an advanced directive. So we provided kind of indemnity on both grounds. And the Mental Health Review Commission has been given a way of making rules and regulations for the advanced directive based on experience. So in our experience, if we find out later on that the advanced directives are not working well, then we do not have to wait for an amendment of the Act. The MHRC can actually make those changes without having to go back to the Parliament for that. So, there's enough protections that we built in so that we're trying out something new which is different. We don't want to create a problem. And it's not compulsory. I think the most important thing as far as I'm concerned that it's not compulsory. And so can I move to the next slide, please?
Yeah.
The point 11 on the IPS was that one psychiatrist from the private sector and public sector should be on the SMHA. We've done that. Okay, so that has been taken care of. If I go to the next slide, point number 12. it says 2 psychiatrists, one from the public and one from private sector should be members of the Mental Health Review Commission. What we have is that the MHRC has 1 psychiatrist with 15 years experience, and there is no public and private. The point is that people have to actually apply. The government is supposed to advertise for this position. They're supposed to have a selection committee and then they appoint the psychiatrist. So, people will have to apply and actually get into this position. But it has 5 members and there is 1 psychiatrist. I don't think in that 5 members we could make it 6 members and say 2 psychiatrists. Because you see, we try to ensure that there are different representations from different stakeholders. If I can get the next slide, please. And number 13.
Yeah.
Yeah, that again is about having other health professionals, and I think earlier Dr. Kala was talking about, we don't have a psychiatrist to certify, how do we get admission certified? So if I can get you to move to the next slide, please.
Yes.
I think I just want to clarify that, look, the provision of the Act is only an enabling provision. So it is not compulsory that the second person has to be a non-psychiatrist. What we said is that 1 psychiatrist is essential. The second person can be a psychiatrist or can be a general practitioner or can be a clinical psychologist or a psychiatric nurse or a social worker. So in a sense, the psychiatrist is essential. And if you have 2 psychiatrists, great. If you don't have it, then there are other enabling provisions. But you don't have to have a non-psychiatrist as the second person who has to certify whether this person is so ill that they need admission. So I just wanted to clarify that this is not a compulsory thing that the other person has to be a non-psychiatrist. If I can get you to move to the next slide, please.
Yes.
We've also built in additional provisions and protections against this. If I can draw everyone's attention to section 115 of the Mental Health Care Bill, and this is what it says. It says very clearly. I'm sure some of our colleagues from Kerala had raised this issue about non-medical professionals prescribing medicines and all. So we've actually put this in to ensure that that does not happen. And we've not had any comment from the IPS on this particular point. But if you feel this is adequate or whether this is not adequate or whether this needs to be strengthened, then that's something that you need to probably give us feedback on. If I can move to the next slide, please.
Can we make a word other than psychiatrist?
Let him.
Sorry, I didn't hear that, Alok.
Dr. Shibhotan suggested that you need a word other than psychiatrist.
No mental health professional other than psychiatrist.
Mental health professional other than psychiatrist. But what he's going to do is he's going to write to you and put it in the mail. Yeah.
Okay,
You're on
okay.
point 14 of registration.
Thank you. See, this is what IPS said in the April 2012 statement. It says that inclusion of the general hospital units will mean that there will become full of involuntary admissions and longer staying patients. I do not understand how that is going to happen, honestly. I mean, are we saying that general hospital units do not admit involuntary patients at all? Is that the position? Then that's a very different position. But just because they are now under the Mental Health Care Bill, I do not understand why they would be full of involuntary admissions. And if I can, over the next few slides, just take you through IPS's positions at various points in time. Look, if I can get the next slide, please.
You're on IPS position at various times.
Well, okay. Before you go to that, maybe the provision in the Mental Health Care Bill, the one slide below that.
You're on it.
Okay. What I want to tell the audience is that we made it very simple. So if you work in a general hospital which is registered under the Clinical Establishments Act or any similar act in the country, in your state. So for example, in Maharashtra, it's the Bombay Nursing Home and it's called the Bombay Nursing Home Act or something like that. Then you do not have to re-register. You just have to send a copy of that to the State Mental Health Authority and with an undertaking that you fulfill the minimum standards, and that's it. So there is nothing more needs to be done. So you are already registered under the CEA or similar act. You just provide a copy of that registration to the State Mental Health Authority. So you already made it easy for people and there is no dual registration. If I can get the next slide, Alok.
Yep. That's IPS position at various times.
That's it.